Competence of the court. Only states may be parties in cases before the court. The court shall be open to the states parties to the present state. The jurisdiction of the court comprises all cases which the parties refer to it and all matters specially provided for in the Charter of the United Nations or in treaties and conventions in force. Whenever the construction of the constituent instrument of a public international organization or of an international convention adopted, there under is in question in case before the court, the minister shall so notify the public international organization concerned and shall communicate its copies of all the written proceedings. The court shall be open to the state parties to the present state. When a state which is not a member of the United Nations is a party to a case, the court shall fix the amount which that party is to contribute towards the expenses of the court. This provision shall not apply if such state is bearing a share of the expenses of the court. Such declaration shall be deposited with the Secretary General of the United Nations, who shall transmit copies thereof the parties to the state and to the Registrar of the court. Declaration made under Article 36 of the State of the Permanent Court of International Justice and which are still in force shall be deemed as between the parties to the present state to be acceptances of the compulsory jurisdiction of the International Court of Justice for the period which they still have to run and in accordance with their terms. In the event of a dispute as to whether the court has jurisdiction, the matter shall be settled by the decision of the court. Whenever a treaty or a convention in force provide for reference of a matter to the tribunal to have been instituted by the League of Nations or to the Permanent Court of International Justice, the matter shall between the parties to the present state be referred to the International Court of Justice. Then the court, whose function is to decide to in accordance with international law, such disputes or as submitted to it shall apply. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states. The international custom as evidence of a general practice accepted as law. The general principles of law recognized by civilized nations. Subjects to the provisions of Article 59, judicial decisions and the teachings of the most highly qualified publicists of the various nations as subsidiary means for the determination of rules of law.